All right, it looks like a lot of people are already online with us, so I'm going to start. Hello, welcome. I am Dr. Ruben Rakoba, a pediatrician from Pediatrust, and your moderator for tonight's live question and answer session, Planning for the Future for the Special Needs Family. Joining me on the panel tonight are some very special guests, including, and if you can, please wave when I give your name so that we can put a face to a name. First up is Katie Clancy, a special needs planning attorney and the parent of a special needs child. Also with us is Stacy Dembo, an attorney specializing in representing children and adults with disabilities in Social Security matters. And Ed Shear, a chartered special needs consultant and certified financial planner. And our own Susie Scheinkop, Pediatrust pediatrician, a parent of a special needs child, and a forceful advocate for special needs children in her practice. We have a lot of questions that came in from our audience members over the last few weeks, and we will try to get to as many of those as possible. Tonight, those of you on the meeting can also send in your questions live, either through the chat function on the Zoom call or through Facebook Live. And don't worry if some of the explanations tonight or discussion seems a bit technical and detailed and you can't get notes or remember everything. We are recording this, and an email will go out either later on this week or early next week with a link to the recording so that you can see the whole thing and stop and play it whenever you want. Also in that email will be several other resources, slides, tables, charts that are referenced tonight. So a lot of that information, if you don't happen to get it or get a screenshot, we'll be sending out those links to you later as well. We want to respect everyone's time, so we'll try and end the session promptly at 7 o'clock tonight. First of all, let's start with Dr. Scheinkop. We all know that each child's situation is unique, but there are some similarities in the challenges that parents of all special needs parents face. Dr. Scheinkop, can you give us a brief description of your journey with your own child? And for those in the audience who are just starting their own journeys, tell us, what are the signs that a child may need further evaluation for delays?
Thanks, Ruben. I feel very honored to be included with this esteemed panel, and I think this information is incredibly important for all parents starting this journey with a special needs child. My daughter Ellie is 24 years old, and she has a rare chromosome abnormality called ring 18. As a result of this deletion syndrome, she has some cognitive impairment, she has hearing loss, she has some physical disabilities. So I have gone through a lot of the many things that parents with special needs encounter. When she was young, we noticed early on, one of the signs was she wasn't making her motor milestones. She was very irritable, had reflux, things like that. And those are some of the things that you commonly see in children with special needs. And those are a good thing to bring up to your pediatrician when you do notice them. And remember, as a parent, you know your child better than anybody, and trust your gut. Moms know this stuff, dads know this stuff. So if you think something's not right, then something's not right. We may not know the name of it right away, but trust yourself. And that's sort of how I went with Ellie. So when she was young and we didn't know exactly what was going on, she was seen by the neurologist. She had a physical therapy, speech therapy, and then eventually we saw a geneticist and got our diagnosis. Ellie didn't walk or talk till she was 3.5 years old. We went through all the speech therapy, occupational therapy, physical therapy, early childhood. She was included at school and she had an aide. But school was a struggle. We had a lot of crying and, difficult time with homework and things like that. And this is a journey, and it's not an easy one. Fortunately, she was able to learn a lot, and as time went on, she was in high school and she got to participate in a learning opportunities program and was integrated in the regular high school in many of those things that she was able to do Special Olympics, and she got to take some regular classes, and so her journey went on. But it was in high school when I started to realize what's next for this child. I struggled so much and spent so much time trying to figure out how to help her get through school. It became obvious, though, when she was a little older, what is going to happen to her in the future? And that's when I started going to lectures like the speakers that are going to be here tonight talking about estate planning, about Social Security, about Medicaid and what kinds of programs and things our children are entitled to. Ellie was fortunate enough to be able to participate in a college experience program at the University of Iowa, where she lived in the dorm and she did her laundry and went to the restaurant and made friends, and it was an unbelievable experience. That was a 3-year commitment. She did not get a degree, it was a certificate, but it was a wonderful life experience, and we were very fortunate that she was able to do that. And as a result of that, she attended a culinary program, and then now she's working in a restaurant in the kitchen, doing some food preparation, which was her goal. So we've come full circle, but these things we're going to talk about tonight continue to be a very important part of her future and planning. One of the several of the things I want you to keep in mind as you're listening to this is it's overwhelming. There's a lot to know. There's a lot to learn. You're going to need to hear it over and over. Don't let yourself get bogged down by being overwhelmed. Seek professional help. The people that are here tonight, Ed, Katie, and Stacy, are wonderful professionals. These are the types of people that can really help you through this journey. And you're going to hear this echoed over and over tonight. It's never too early to start planning. So I think those are the things that I would want to leave you with. And I'm interested to hear what everyone else has to say tonight too.
Thank you, Susie. I know you're not shy about sharing your journey as a special needs parent, but it's always very helpful hearing the real world experiences of somebody who's lived through it. So thank you. And it's a great story, a college experience for somebody like that, a job. It's very heartwarming. So thank you. Oh, and by the way, many of the questions that we're dealing with over the next 50 minutes or so will be very specific to some of the technicalities of trusts and power of attorney and this and that. So at any point, Susie, if you can jump in and give us a real world experience of how you and your family dealt with that situation, I think that would be helpful for our audience members.
Great.
All right. We're going to send the next question to, I think, Stacy. Stacy, you've done a lot of work representing families in Social Security issues. I know I've had dealings with Social Security personally, and it is a Byzantine structure to navigate. We have 2 questions for you. What government benefits are available for a person with disabilities? And how would a parent's retirement affect a special needs child's benefits if they retire when the child is still a teenager?
Thank you for those great questions, and thank you for having me. Yes, Social Security is complicated, and so I'm going to try it. I could probably talk about these topics for like 5 hours. So I'm going to try to just give you a little bit of information, and then you're going to be getting some resources from me after the presentation that's going to expand on what I'm talking about. So first, I think it's important that we separate by age category. So when we're talking about benefits for people with disabilities from Social Security, there's one type of benefit that's available for children, which would be birth up until age 18. And then there are a few different types of benefits that are available starting at age 18. So first, for children, there's a benefit called SSI, which stands for Supplemental Security Income. That benefit is available to a child who meets Social Security's definition of disability for children, which is different than their definition for adults, number one. And number two, that the family, the parents that the children are with, meet certain financial eligibility criteria. So SSI is a means tested benefit, and that is also true for the adult version of SSI. But for the children's version of SSI, Social Security looks at the financial picture of the parents, and they consider that to be the child's finances through a process they call deeming. So most people are not going to, their children are not going to qualify for SSI financially, but definitely there are many people who do, and I do represent a lot of children in SSI cases. So if you're listening to this talk today and you have a child under the age of 18 and you think your family might be able to qualify for SSI financially, and people's financial circumstances have clearly changed over the past several months. So if someone wasn't eligible before, they may be now. The best thing to do would be to contact Social Security and go through the financial application. And you can't go to Social Security right now, but you can do the application with them over the phone. SSI, regardless of whether you're a child or an adult, the amount of money that you can receive, I should say SSI is a monetary benefit, it's cash that you get every month. In 2020, the most that somebody can receive from SSI is $783 per month. That's going up to $794 next year, they just announced. That's called the federal benefit rate. That's the most that somebody can get from SSI. And then SSI can also be reduced based on income. And I'm going to share a slide with you in a moment that's going to talk about how that plays out in the adult setting. But that's also true for kids. So shifting gears to adults, once somebody turns 18, they're considered to be an adult in the eyes of the law, and the same is true with Social Security. So for adults, there are two different types of disability benefits that are available. SSI, like we just discussed, and then the other one is Social Security Disability Insurance, or SSDI. The major difference between SSI and SSDI is the financial piece of it. So as we just were discussing, SSI is means tested. For an adult, once they turn 18, Social Security does not care about the parents' finances anymore. They're going to be looking at that child as their own individual entity. And so if that now young adult has less than $2,000 in financial resources and limited to no income, they could qualify for SSI from a financial perspective, and then could be receiving up to $783, soon to be $794 per month. SSDI, on the other hand, is a form of disability insurance that people earn through work. So the way that that plays out is we all who work are probably familiar with the FICA taxes that are withheld from our paycheck. FICA is the tax that goes to Social Security, and it purchases for us retirement insurance and also disability insurance. So for people who have been working and paying FICA taxes in, they can become insured in the disability system. And when you're a young adult, you don't have to have actually worked that much or paid that much in order to gain that insurance. So for someone under the age of 24, you only need what we call 6 quarters of coverage, which is basically a year and a half of work. And it doesn't need to be full-time work to gain that SSDI eligibility. Then the amount of benefit, the monetary benefit that you would receive is going to be dictated based on how much you've paid in. So for a relatively low wage earner, the SSDI benefit might not be that much. The other benefit that accompanies SSDI is Medicare eligibility. So after somebody has been receiving SSDI for 2 years, for 24 months, they can become eligible for Medicare. And I should say, I don't think I said, when someone's on SSI, they can qualify for Medicaid health coverage. So those are the two traditional disability benefits available for adults. But then to get to your second question, Dr. Rakoba, which having to do with a parent retiring, I think what that is getting at is what we call DAC, or Disabled Adult Child Benefits. So whereas in the most common form of SSDI, someone becomes insured through their own work history and starts to draw a disability benefit based on their own earnings history. The DAC benefit is when a disabled adult child draws a benefit on the parent's Social Security earnings history. And the way that that works is the child, the young adult, has to be able to prove that they became disabled prior to age 22, which is what Social Security calls the developmental period, and then meets the criteria for disability ongoing without any break in their eligibility. And also they have to be unmarried. If you can meet all those criteria, then when the parent retires, the disabled adult child can draw a benefit that's 50% of whatever the parent's retirement benefit is. So versus, let's say, $783 a month in SSI, that DAC benefit for some families could be significantly more money over the course of that young adult's life. That young adult can also get Medicare after 2 years of receiving the DAC benefit. And when the parent dies, the benefit will go up, the monetary benefit will go up from 50% to 75%. So it can be huge in terms of, you know, the financial piece over the course of that young adult's life. I want to say just a caveat to that, which is when families are thinking about DAC eligibility for their children, it's very important that they be very mindful of not having their child engage in any disqualifying work activity. So one of the materials that you're going to get from me after this is discussing what we call substantial gainful activity, which is how much money a person can earn and still be considered to be disabled. If somebody is going to try to become a DAC, they should not engage in more than 9 months of substantial gainful activity, because otherwise they're going to lose the opportunity to become a DAC forever. It's sort of complicated, but if this is something that is your plan, you have to be very mindful about work. The other thing I want to share with you is when I share my screen, this is something that I think is important for families. I hope everyone can see this. This is the slide that you're going to get from me at the end of today's talk, which talks about how SSI is impacted by income and earnings. And I made an example of what it would look like if a person is receiving SSI and then starts working in a part-time job, and how your earnings from work will reduce your SSI. But in this example, and you're going to get this from me afterwards, so you don't need to study it. But in this example, this person is earning $450 per month, and it will reduce this person's SSI by $182 because of the formula that Social Security uses. But at the end of it, they will still come out with more money than they would have received otherwise. And I think that it is important message for everyone to know that just because someone might be on Social Security, that doesn't mean that they can't work at all. Work is a very important part of many people's lives, even people with disabilities. And there are ways to be on Social Security and to work, and to have the two work together. I hope I covered everything.
Yes, you did. It's a lot of information.
A lot.
But all useful. I think a couple of takeaway points there for somebody who's hearing some of this for the first time is that it's probably helpful, obviously, as Dr. Scheinkoff mentioned earlier, to start planning as early as possible, and to not take any financial maneuvers lightly. Anything at all can tip the scales one way or the other, working, not working. And it's the other thing I got from that is it's probably helpful to get a professional involved as early as possible as well, to start with the planning process so that you don't make some mistakes that you can't undo later on. So thank you for all of that, Stacy. Ed, we're going to go to you next. We have a question for you. One of our audience members asked, I'm trying to save as much as I can for my special needs child. Will the savings take away government benefits from my child? And what can I do to protect both the savings and the government benefits?
You're on mute.
I think you're on mute.
Perfect. Thank you. Sorry about that.
That's all right.
Thank you. Thank you. It's an excellent question. I think the answer is it depends. How are we saving for our child? Are we saving the money in our child's name or in our name for the benefit of our child? And the question didn't exactly explore that. So let's look at that a little bit. As Stacy just mentioned, there are those two programs, SSI, SSDI. With SSI, there's that means test, which is a fancy way of saying that you can only have so much money to your name. And so if the parent is saving the money in the child's name, well, that may increase how much money the child has and then make the child ineligible for those benefits. And what happens is they get put on pause and you have to spend those benefits down before SSI comes back on. And so the best way you can do this is to save the money in your own name, look at saving it in your retirement account, or even better, we want to save it in a way that will eventually get to the child's benefit, but is not going to be in the child's name. And that's an area where Katie really has the expertise on the trust planning. But if the child does have this money in the child's name, we can look at different vehicles to put that money in so that the child does get benefits in the future. And that could be the ABLE account. And there's also special kinds of trusts that can work as well that would hold the child's money. And this way, it protects that money for the child's use, but allows the child to get those benefits in the future.
Thank you. So you mentioned, can't keep the money in the child's name for him or herself, but there's ways, legal ways around that. And that is exactly what you mentioned, the trust. So let's bring in the expert on trust, Katie. What can you tell us about what a special needs trust? When does a child or a young adult need one? What are the different kinds? I know there's a lot of information there, and like Stacy said earlier, you could probably do a few hours just on trust. But what can you tell us that would be helpful for our audience members?
Sure. Well, I think I would start with an overview of some of the different tools and techniques we can use to help that child or the young adult remove the money from their balance sheet or their name. And as both Stacy and Ed referenced, that anything over $2,000 is a problem for their benefit eligibility. So in our toolbox of legal techniques that we can use, there's something called a third-party special needs trust. That's probably the most common trust and the ones that most people are familiar with. And there's also a first-party special needs trust, and then there are ABLE accounts. So those are three different vehicles that we can use to then take the money from the child's account and put it somewhere separate. It allows them to then remain eligible for government benefits. So when we're trying to determine which tool do we use and when, it really comes down to the source of the money. Where did the money come from? Did it belong to the person? Maybe it's a bank account that held their birthday money and holiday money for all these years, or maybe it's a gift from their grandparents or an accidental inheritance. Grandma or grandpa passed away and left this child a small gift, not realizing that it should have been put in a special trust. When it's the disabled person's money, and if it's under $15,000, we can use an ABLE account. Then every year that $15,000 limit renews, and the person, if necessary, could put another $15,000 into that account. An ABLE account, I think Ed is going to talk a little bit more about ABLE accounts later in the presentation, but they're very inexpensive. You can set them up yourself. They are also, let's see, savewithable.com is a source on the internet where you can get more information. But they're very inexpensive and a nice way to protect that money. It's also an account that a working person can put some wages in, again, up to $15,000 a year in Stacy's example, and where someone's earning a smaller amount. It's a perfect type of tool to address the situation. Now, if the person has more than $15,000 through the inheritance or earnings or savings bonds or what have you, then they would need something called a first party trust. And it simply means that the person who is disabled can put their money into the account. However, the trade-off to this is that if the person is receiving Medicaid benefits upon their death, Medicaid could collect whatever that amount might be that was spent on that person's behalf during their life. But it's only at the end of the person's life, and it's only if there is any money left in that first party trust account. And then going to as I said before, probably the most commonly used trust being the third party special needs trust. That is a great vehicle for everyone else's money, not the person who has disabilities, but their parents, their aunts, uncles, friends, what have you. Anyone else can put money into this account. This is probably the most common and the most desirable, definitely the most desirable trust, because there is no Medicaid lien opportunity. So when the person with special needs passes away, if there's money remaining in the account, it can be given to whomever the parents would like. They can leave it to other children, siblings, charities, whomever. And the commonality of these three vehicles is they all accomplish the same few things, which is to protect the person, make sure that they can remain financially eligible for benefits, protect their money. So if we're concerned about the financial vulnerability of the person being taken advantage of, or maybe needing help managing their money, all three of these trusts will help that as well, and with the trustee helping manage this for them.
Thank you. So just to remind everybody, Katie mentioned, there's several different kinds of trusts. There's different rules for how much money in each and this and that. It can all get, a little bit overwhelming. We will be sending out her a little chart and graphs that sort of breaks down each of those with limits and all of that information that she just went over. So that will be coming to you in the email. To personalize the idea of a trust, I'd like to ask Dr. Scheinkopf this next question. Susie, did you set up a trust for Ellie, and what was your experience with that process?
So yes, we certainly did. We were overwhelmed at this prospect. So Ellie had some money in her name that she had gotten from grandparents, and that would have made her ineligible for SSI. So when we went and met with a special needs attorney, we established both a third-party trust and a first-party trust, so that the money that had been in her name prior to the look-back period for Social Security went into the first-party trust. As Katie just referenced, that would be a lien against it, against her Medicaid benefits or other benefits. For Ellie, as I mentioned before, she went to the University of Iowa to a college experience program, which is the price of a regular college. So we tore through that money in the first party trust pretty quickly. So I know the trust still exists, but I'm not sure that there's actually any money in it anymore. And that's the advantage of doing something. She could utilize the money that had been given to her. By putting it in this trust, we were able to spend it down in her name, but it did not make her lose her SSI benefits. So those are really important things, and there's no way I would have known anything about anything like that had I not sought out the expertise of a special needs planning attorney.
That's a good question. I'd like to ask a follow-up to Katie, if I can a surprise question on you, and that is, is there any benefit to saying we're going to establish this trust before my son or daughter turns 18, so that, you know, it doesn't look like you're doing something nefarious after 18? She's come into some money from grandma or grandpa or an inheritance, and then you try and shove it into a trust. Is there any, uh, you know, advantage to setting up the trust before they turn 18?
Well, it depends on which trust, which type of trust you're referencing. Certainly a third-party trust can be established at any time, and often parents do set it up early on and don't fund it for a long time. They don't actually put money into it until later, or perhaps even not until they pass away. I think that the question of when to set up the first-party trust, it's usually a reaction. It's usually set up as because we become aware of something that was and like I said, an accidental inheritance, which is what happened to Dr. Scheinkopf. Usually that's when we set them up. The only other time that it's a little bit more of a planned strategy is when the money is the result of a settlement. So for example, maybe someone was in a car accident and they received a settlement because they had a permanent injury. And let's say that was $100,000. Because that money went to the child or the young adult in their name, that is something that we know is a first party issue. So we would set that account up right away, and automatically by putting the money into it, we would avoid any of the other time requirements. But I think what you're referring to is that look back period. So when we apply for benefits, for example, for SSI, you have to have less than $2,000 in your name for the previous 3 years, not just the day you turn 18. It's really since you're 15 years old, well, when you're 15 and on. So sometimes parents will call me and say, oh, little Johnny did have $5,000 from his grandparents, but don't worry, it's gone. We transferred into our daughter's account or our other child's account. And obviously that can be kind of an issue, but I think most of the time parents don't realize, or if they do, they're not sure how to handle that particular amount of money. But at any time when we recognize that that's an issue, we can set up a first party trust. As soon as the money goes in, it eliminates that 3-year look back problem. So we no longer have to worry about fraud or any, questionable behavior. As long as we put it into an approved tool or an approved technique that I was describing earlier, we're okay.
So, that's a good point. There's, you don't want to get in trouble, obviously, with the authorities or the IRS or Social Security. And, setting up a trust doesn't mean, oh, I've got millions and millions of dollars, I need a trust for my family. No, you're talking, real world dollars and cents. And, even small amounts of money, as we've seen, can affect your benefits. So setting up a trust sounds like, a really good idea for most people. So thank you for that. Speaking of an inheritance, we had one question, and I'm going to pose this one to Ed. What are the pros and cons with regards to giving a child money each month in an inheritance versus in one lump sum? I'm assuming a lot of that depends on the status of a trust or whatever, but what can you tell our audience about that?
Hi, another good question. Once again, I would be referring back to the status of their benefits and their age. And maybe the best thing that we can do is not give them the money directly, again, because it will impact their benefit eligibility, but rather give that money to the trust. If it's my money that I'm giving to my child, well, instead of giving it to my child, I'm going to give it to my child's special needs trust. That's the third party trust because the money originated from me, and that's where I'd put it. From there, if I wanted to drip some money to my child from that trust, the best way to do that is, again, into, say, the ABLE account. And that gives them some measure of control, gives them some spending ability. The ABLE account, you can actually link a bank account to it. It's done through the ABLE website. You can set up a bank account with Fifth Third in Illinois. and it gives the child can have a debit card with spending limits. It allows them some spending opportunities and to feel like a whole person, to be able to go out and buy things that they want. So I would recommend that the large sum of money be transferred into the first party or into the third party trust, and then a little bit here and there can be used into the ABLE account. The ABLE account, just like that first party trust though, has the Medicaid pullback at the end. So we don't want to fund a lot of money into the ABLE account if we can help it. There are some benefits of the ABLE over the first party trust. But again, we're trying to keep those dollars in those accounts as low as possible from the standpoint of the Medicaid clawback down the line.
Thanks. That's helpful. All right, we're going to shift the focus just a bit. We've been talking a lot about benefits, finances. These are obviously very important issues, but another important issue is just day-to-day life. Who's going to take care of my special needs child as a young adult? Will it be the parent? Will it be somebody else? What happens when the parent passes? Katie, what can you tell us about the difference between guardianship and power of attorney? What kinds of rights does a person under guardianship retain, and what kinds of rights do they lose?
Good question. This is a question that comes up, especially as the 18th birthday. Usually 3 or 4 months before an 18th birthday, we tend to get a call from the parents wondering what should they be doing. And so to start, I would explain the difference between guardianship and power of attorney. Guardianship is a court procedure that allows another person, parents usually, establish legal control over the financial and personal decision-making process of an individual, called the ward. We refer to the person who is under the guardianship or the child as a ward. The power to make these decisions is transferred to the guardian permanently, indefinitely and permanently. So it is kind of an extreme form of intervention. Not a bad form of intervention, but it definitely is the most powerful thing that a parent can do once a child turns 18, versus the power of attorney. Powers of attorney can be established for either property or asset decision-making, or personal, so over someone's health care and personal decision-making. Powers of attorney are not permanent. They can be temporary, and they do allow the person who has disabilities to maintain more control over their own lives. It allows them to preserve some decision-making. Sometimes maybe it's on their own completely, or with their power of attorney when they need help. So they're really two very, very different forms of help, mainly in the sense of how much power does the parent end up having. The second question that parents ask most commonly is, well, how do I know which one is right for my child? And so our advice is to always start with the least restrictive measure, just like we do in school, just like we always talk about with our IEPs. Which path is least restrictive for my child? And that's always going to be to start with the power of attorney. You can always begin with the power of attorney, and as time goes on, maybe the parents will decide, you know what, guardianship is the right thing for us. But they took the time to practice and vet it out and really be sure it was the right strategy for their child. If necessary, then they can proceed to guardianship. So I think I would also suggest a few questions for the parents to think about when they're making this decision. And one is, how does the person understand what types of decisions need to be made? What is the decision before them that they need to make? Do they know what their options are if they're trying to make a decision? Do they know what the consequences of the decision making will be? And finally, once they do make a decision, can they then carry it out and inform others of the decision and take the steps necessary to reach their conclusion and effectuate the decision? So if your answers are no to many of these, then guardianship may be more appropriate. It really is an art and a science that requires some discussion and consultation to determine which one is better. You also asked me, what rights do you give up by becoming, taking guardianship of a person? And certainly that person then cannot form their own contracts. They cannot marry. But on the other hand, some see the inability to form contracts as a benefit and a protective measure, that the child or the young adult rather won't be responsible for contracts they make because they don't have the required capacity to make them. So those are the different variations of guardianship and powers of attorney.
Thank you. We got a question that came in on the chat just now while you were explaining that. And if you can you answer this? Is there such a thing as partial guardianship?
Yes, it's called limited guardianship. And a good example of a limited guardianship is if you have a person who needs assistance, maybe making financial decisions, or but they don't necessarily need help with everything. Or another example is a person who's going to drive. Driving is considered a really big issue. Some feel that driving is allowed under guardianship, and some feel it isn't. I'm in the camp where I think it's not a good idea to. I don't think that it would be approved to have the right to drive when you are under a full guardianship. So what you can do is carve out certain rights and go before a judge and explain that you're seeking a limited guardianship, and the specific right that you don't want to have under the guardianship is the right to drive. You also can divide guardianship in two ways. One is guardianship of the estate. One is guardianship of the person. Very similar to how we have powers of attorney for property, we have powers of attorney for health. Under guardianship, it's just referred to a little bit differently, but it's essentially the same division. So the answer to that question is yes, you can have a partial guardianship.
Thank you. You know, I'm going to ask Dr. Scheinkoff this next question. She's experienced this on both sides, I believe, and that is when you apply for guardianship, there's a very lengthy form that needs to be completed by a physician. As somebody who's done that multiple times, Susie, what can you tell us about what's important for those physicians who may not be familiar with this form? It may be the first time they're seeing this, and it's helpful to have our parents in the audience be as informed as possible and help guide the physician through that process. What can you tell us?
Well, it's very important for the parent who needs a guardianship form completed to try at least to have it completed by somebody who knows their child well. That's number one. It is not a 2-second conversation. So I strongly recommend that the parent make a visit with the child present so that the physician can truthfully attest to the fact that I have seen this patient and this is the state of this patient. And then what's really important on this form is to be very specific. And I always write on my forms, because this is always true of mostly everybody that gets guardianship, is number one, that this disability is permanent. It's not going away. That the most important thing that I can see is that this person cannot make decisions regarding their own medical care, that this person cannot make decisions regarding their own finances, and that this person cannot make decisions regarding their personal safety. I think those are really, really important things to point out for the legal system to know this is why this person needs a guardian. I also think it's important to say things like, this person needs assistance with activities of daily living. This person needs assistance with transportation. And then there's a section at the end that talks about where, as a physician, do you see this person? And I think that parent needs to say, I plan on this person living with me for this amount of time. They're going to this kind of program, and give very specific details. And I think that is a very helpful document for deciding guardianship within the court, and that also that document can be used later to help with Social Security benefits because it helps elucidate the condition of the person seeking guardianship and benefits.
Thank you. And I will put in a plug for pediatricians everywhere, not necessarily a pediatrician, but for some parents of special needs children, they sometimes don't see a regular physician or pediatrician. They have a lot of specialists who deal with different parts of their child's condition. And they get a flu shot at the OSCO, and they go to the urgent care when he or she is sick. And even if they do go to one place, there's often, 2 or 3 different doctors that see them. So I'd put in a plug for, if you can, before the child gets to the guardianship stage, to establish a real relationship with somebody who knows your child very well, so that filling out these guardianship papers is not, a very arduous task. And there's a lot of information that needs to go in there. And the more accurate it is, the easier it will be for you during that whole process. All right, thanks. Stacy, we're going to address this next question to you. One registrant asked, my child with special needs is 16 years old. What kind of information or testing should I be collecting now to prepare for an SSI application?
That's a great question. So Social Security is looking for evidence usually that falls in 2 categories. One would be medical records and the other would be school records. So from a medical records perspective, that's going to usually be just the appointments that your child is going to with their pediatrician, other specialists. You don't really need to generate information, but maybe keep a log of where he or she is going, so that you can provide that information on the application, because the application will ask, where has this person been going? And then you provide a medical release form. So you don't need to collect the evidence necessarily, but just be able to provide the information. From a school records perspective, I would start saving IEPs. Also, the triennial evaluation is done by the school every 3 years if this child has an IEP, or saving 504 plans if this child has a 504 plan. I also would save, like, for example, in a situation where a child has a lot of behavior issues and maybe there's disciplinary write-ups or things of that nature, that usually doesn't come in the IEP. So by saving those notes when they come home from school and things like that, and just building a file, all that can be very helpful. Guardianship paperwork, like we were just discussing, if that's going to be a piece of the puzzle here, that medical form, which is a statutory form in Illinois, everybody that's going for guardianship would have to have the same form, but it can be very helpful, and having a doctor fill it out in a very robust way will be helpful for the cases Dr. Scheimkup said. And then I also want to put a plug in for thinking about at the IEP meetings, especially as your child is getting close to 18, and then also during the transition years, if that is going to be 18 to 22, if your child is going to be in a transition program, thinking about when you're at the IEP each year, that the information in the IEP is going to be evaluated by Social Security. And so I notice a lot in the work that I do that parents go to these IEP meetings, and when they're asked, what are your concerns? They either say nothing or they say everything is great. And then that's what gets recorded on the IEP. And then to Social Security, it can have a different meaning than maybe what it meant in the IEP meeting room. So just to think about what information you want to be heard by the Social Security audience down the road, and trying to get that into the IEP as well. Regarding testing, if this is a situation where we're talking about an intellectual disability, and maybe there's you want to show evidence of an IQ under 70, which can be beneficial for a Social Security case, You wouldn't want to have that new psychological testing done until your child is 17, because then the psychologist can use the adult scales, and that will be helpful for the Social Security case. So, you know, every case is different. Every child is different. It really depends on what the issues are with your child, but definitely maintaining medical treatment and being thorough with your school records can be very helpful.
Thanks, that is helpful. As a follow-up, another parent asked the question, I applied for SSI for my child, but was denied. Does this mean he will never be eligible for SSI? I really believe he won't be able to work and he needs this help.
So, I mean, the first question I don't know the answer to is, why was the case denied? Was it denied for financial reasons? You know, then you need to speak with somebody like Katie potentially to fix that problem and then refile. If the case is denied for medical, vocational reasons, the answer, I think, is you shouldn't be discouraged. We know from statistics that 60% of initial applicants are denied, and that's looking at all different types of cases, people that are applying for cancer or whatever, you know, back pain, all the way through, you know, the types of cases that we're probably talking about. But the point is, most people that try to get on Social Security are not successful initially. And then you need to go through the appeal process. If this application was denied very recently, within the last 65 days, you should file an appeal. And you can go to the Social Security website, which is ssa.gov, and you can do it tonight even. It takes like 20 minutes. So if it's been more than 65 days, really the appeal deadline is 60 days, but they give you 5 extra grace period days. You can refile. And if you go through the medical adjudication and the case is denied again, you should appeal. But just be forewarned that at the first appeal, which is called reconsideration, the odds are even worse, and only about 10% of cases are approved at that phase. And so the next thing to do would be to request a hearing with a judge, which is what, you know, I represent people at hearings with judges multiple times a week. I've done more than 1,000 of them. So I can tell you from a lot of experience that many people that were denied twice get benefits after going to a hearing. So I think the moral is you shouldn't be discouraged. You may need to talk to an attorney or an advocate, and you should be aware that attorneys that practice in this field, our fees are regulated by Social Security, and we can only charge if we win our clients' cases. So, and our fees are paid by Social Security. So everybody can afford us. So that shouldn't be a barrier to finding representation.
Thank you. And to reiterate, I would say that I had a similar instance of denied Social Security benefits, and, you know, got an attorney who, this is what he does every day. You know, went into the hearing, boom, boom, boom. Yes, he argued successfully, it was taken care of. The appeal was granted and the benefits were given. So, you know, Stacy's right. Don't give up, persevere, and, you know, it should work out. All right. We have time for one last question, and I'd like all of you to chime in on this. We'll start with Katie first. The question was from a parent who has 2 children. One is 18 with Down syndrome, and the other is a child who's 20 with autism. The parent asked for recommendations for the issues they should be reviewing at this point in the child's life. Katie, we'll start with you, but I'd like each of you to jump in if you can to give some advice. What can you tell that parent?
Well, both of these young adults are in the transition phase, in that age range that is our opportunity to obtain benefits for them as early as possible, as Stacy was describing, in order for them to be considered a DAC, which exponentially can increase their benefits later in life. So the first thing I would recommend is a benefits assessment to understand what to apply for, when, and begin that process as quickly as possible. Secondly, if they are still in the transition program, I would want to review the IEP and ensure that they're obtaining as much as possible through that program, mainly in the vocational piece, the work setting. Again, to load them up on credits to obtain good government benefits. And then third would be a legal plan, and to understand one, are they going to need powers of attorney or guardianship? Has that decision been made? Does the child have any money in his or her name? Because that's the next thing, is we have to prepare that person for the financial piece of benefit eligibility. And that may require different types of trusts or an ABLE account. And then of course, to make sure the parents are prepared and set up with their own estate, so they don't actually cause their child to lose benefits someday in the future. I would also suggest a financial review, and I'm sure Ed can speak more to that.
Thanks, Kitty. Absolutely. With children of this age, what we don't know is where are they going to live in the long term? What is that going to cost? What services are they going to need? Will this be provided for by public benefits or private by the parents? And so I'd like to take that lens and kind of turn it around initially and look at the parents to make sure that they are doing everything they can to ensure having the resources for the future. So it's a financial plan for the parents first, because as the parents are working and contributing to their own retirement funds, well, the parents are going to need that money themselves. And so we need to say, on top of the parents' retirement, are we also looking at the additional retirements of their children, one or both? And so how much more money is that going to take? And what tools can we use to help ensure continuity of care? And who's going to pay for that? Not only when the parents are alive, but also then after the parents pass. And so we can use some different insurance to help bridge the gap. We can make sure that the parents are contributing as they need in their plans to really make up as much as they can. As Dr. Scheinkopf said in the very beginning, it's never too late to start planning early. So we're not going to beat ourselves up if we haven't started already, or 5 years ago or 10 years ago, as the question was, hey, I've got kids who are 18 and 21 or 22. Well, what can we do now? What can we start with at this point in order to give ourselves the best chance for that future that we're hoping for ourselves as parents, but also for our kids?
And from a Social Security perspective, for the 18-year-old with Down syndrome, assuming there's no disqualifying resources, if there are, talk to someone like Katie, but assuming that's been already dealt with, the child with Down syndrome, it's a pretty straightforward application for SSI. So I would highly recommend filing for SSI. Down syndrome is a listed impairment. So you really only need to be able to prove that your kid has Down syndrome, either with genetic testing or with a statement from a doctor, basically attesting to it. So that one would be pretty easy, or straightforward, I should say. But the children with autism, young adults with autism, I represent a lot of people on the autism spectrum, and depending on where this person is on the spectrum really is going to dictate how easy or difficult the application and appeal process may go. So I would suggest starting early, collecting your evidence, getting all your ducks in a row in terms of making sure you have your IEPs, et cetera, and filing or retaining an attorney or an advocate to assist you with filing for that claim, and then not giving up if the case is denied, because it's not uncommon that Social Security doesn't really understand people with autism, especially people on the autism spectrum that are verbal and often very bright and can engage in a conversation. They just don't understand that version of autism. So it often takes some explanation, and support from like transition records often are really helpful, or from supervisors in different work programs that can speak to different challenges that this person has had functionally. So that one might be a little bit more challenging, but it definitely could be worth pursuing, and I would start early.
Thanks to all of you. I opened up the session tonight with Dr. Scheinkopf, and I'm going to close with her. Susie, do you have any parting words of wisdom that you can give to our audience members?
Well, this is not an easy process. It's an emotional process. It's a difficult process. I think as these, experts have said tonight, there's so much to know that as a parent, and I consider myself a pretty informed parent because I deal with this. I dealt with it in my career before I had a child with special needs, but there's just so much to know. And I think it is such a worthwhile investment to get people involved with your child's future that can really put the plans in place to have them cared for, to have them financially stable. This is really important. And if you think about what these things cost now compared to not getting the benefits that they're truly entitled to for a lifetime, it's really a small cost. So I would strongly encourage parents to, talk to their pediatrician about what they need medically, but to work with people like Katie, Ed, and Stacy to help develop a life plan for their child's successful future.
Yeah, amen to that. I agree with all of that. All right, we are at our limit. I want to respect everybody's time, so we're going to finish up. Again, email will be going out to everybody who registered for this event with the recording and the link to the recording you can get online. It'll also be posted on our website at pediatrust.com and at Katie's website as well, ClancyAssociates.com. And we'll be sending out all the other resources that we mentioned, some of the slides, the graphs, whatnot, in that email as well. So good luck to everyone. Thank you for joining. This has been very educational. And I want to thank all of our panelists tonight, Katie, Stacy, Ed, and Susie. Thank you all. And everybody have a good rest of your week. Bye-bye.
Thank you
Thank
very
you.
much.
Bye-bye.
Bye.